Now, as is customary, I should note that these views are my own, and I'm not speaking on behalf of the Commission or the SEC staff. All right, I got that out of the way.
Despite the pandemic, and frankly, despite the lawsuit from the SEC, 2021 has been a record year for us. Things continue to grow. For those of you who aren't familiar with Ripple, at the core, we are a technology company selling solutions for cross-border payment, cross-border settlement. In our technology stack, we use a digital asset called XRP. XRP is one of the leading cryptocurrencies out there.
Those tokens being offered, many of them are offered and sold as security.
The SEC filed suit last December asserting that XRP is a security.
There's actually a lot of clarity on this front. So you see, in the 1930s, Congress established the definition of a security, but they included like 20 different items. You'll be familiar with some of them: stock, bonds, notes, but one of the items is called an investment contract. In the following decade, the Supreme Court took up what's the definition of this term? Black letter law, investment contract. This case said an investment contract exists, and I'm going to quote for a moment: a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter of a third party.
The one thing I would add is the other elephant in the room, I think, is the lack of clarity that has gone on in this industry. And, for years, I think the crypto industry has asked for that clarity. And yet, we're still getting this kind of, hey, yesterday we heard it is clear, yet a few weeks ago, we had two commissioners and Pierce and Roisman saying, a letter, and I'll quote, they said a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading. So to me, one of the elephants in the room is we can't keep saying it is clear and then trying to make it clear through enforcement. You see other G20 markets like the UK, like Japan, like Switzerland, like Singapore, who have been proactive and engaged. And that has helped these markets thrive in those countries. If the US wants to be a leader in this space, then we need to provide that clarity and not act like there is clarity.
You might have heard of it. It's called the Howey test, related to an estate of William Howey that actually was about orange groves in Florida. And what do orange groves in Florida have to do with cryptocurrency? Well, the Supreme Court has upheld this test a number of times subsequently. And so further, there are other tests. There are many other determinations comes under the federal securities law. Now, my predecessor, SEC Chairman Jay Clayton, I think, said it well in 2018 in congressional testimony. He said, to the extent that digital assets and I think he named Bitcoin, but he said, to the extent that digital assets like initial coin offerings or ICOs or securities, and then he goes, and I believe every ICO I have seen is a security, we have jurisdiction. Federal securities laws apply. I find myself agreeing with my predecessor, Chair Clayton. You see, generally, folks are buying these tokens in anticipation of profits. That's the core thing the Supreme Court said. And there's a small group of entrepreneurs and technologists standing up and nurturing the projects. Geez, anticipation of profits, small group of entrepreneurs standing up something. Our federal securities law says there's a need for some protection. And I believe we have crypto market now where many tokens may be unregistered without requiring the disclosures and the market oversight. This leaves prices open to manipulation. This leaves investors vulnerable. Now, over the years, the SEC has brought dozens of cases, many of them during my predecessor's time. I've only been here 3 months. And yet, having brought dozens of cases, we haven't lost a case. So some might wonder, what does the SEC have to do with crypto? Primarily, crypto assets provide a digital, scarce vehicle for speculative investment. Thus, in a sense, one can say they are highly speculative stores of value. Buy Bitcoin, it goes up. Maybe I have something better for my future and my retirement, but it's not really being used as a unit of account. And we also haven't seen that crypto has been used much as a medium of exchange, except for one large exception. To the extent that it is being used as a medium of exchange, it's usually often to skirt our laws with respect to anti-money laundering, sanctions, tax collection on the dark web. And yes, also it's enabled extortion via ransomware, as we had seen recently in Colonial Pipeline and elsewhere.
Yeah, we have come a long way from the days of Silk Road. And I think, to discount the real use cases because of actions of a few, which again, some of this technology may have been born of an anti-government and anti-bank and all those kind of things. That's not where we are today.
If you want to invest in a digital, scarce, speculative store of value, that's fine. Right now, though, in this digital, scarce, speculative asset, Bitcoin and others, we just don't have enough investor protection. And frankly, at this time, it's more like the Wild West than some sort of protection against fraud and manipulation in the space. This asset class is rife with fraud, scams, and abuses in certain applications.
Core frameworks like AML, KYC, those don't have to go away in a world of crypto or blockchain enabled payment infrastructure. In fact, for Ripple, we only work with regulated endpoints. We only work with you can't have a Ripple enabled transaction that circumvents KYC or circumvents AML monitoring. And so I believe that the core framework around how we regulate our financial institutions globally, and again, if you're in Brazil and you have a capital flow control, well, that's enforced at the endpoint. The infrastructure pieces that can be massively more efficient in terms of speed and cost don't have to change how regulations are applied at endpoints.
It doesn't mean there aren't good faith actors, and there are many of them, but investors really aren't getting the information to judge the risk and understand the risk. And I fear that if we don't address the issues, I worry a lot of people will be hurt. Let me just say before I conclude, I'd like to note that we have taken and will continue to take our authorities as far as they can go. And certain rules related to crypto assets are well settled. For instance, the test to determine whether crypto asset is a security is clear. Now, some in the industry would say it's not clear enough, but I would say I agree with Jay Clayton. It's clear in this regard.
Since the SEC filed their lawsuits to get Ripple, we have signed dozens of new contracts with banks, with payment providers around the world, and I think only one here in the United States. The lawsuit effectively has stymied the United States customers. Like, well, if the SEC is doing this, and some of these are public companies, like, we're not going to touch this until there's resolution. That just puts us further behind.
Regulators would benefit from additional authorities in this space. We can also attach things around sanctions and tax collection and tax compliance and anti-money laundering. So it's about all the policy suites right there. Now, right now, large parts of the field of crypto are sitting astride, not operating within regulatory frameworks that protect investors and consumers, guard against illicit activity, ensure for financial stability, and yes, protect national security. Standing astride isn't a sustainable place to be. Technologies for generations have come along. They might stand astride public policy for a while, but for those who want to encourage innovations in any field, but if you're encouraging in crypto, I'd like to note that financial innovations throughout history don't long thrive outside our public policy frameworks. And I would also note to some that are thinking of investing in this space, private monies also often fail. And one could study a little bit of history in the US. We had a lot of private monies during the wildcat banking era of the mid-19th century. If US investors are getting exposure or buying or selling these, then our remit is to ensure for investor protection. And if we do that well, I think that not only do investors benefit, but if this innovation has any chance of surviving into the late 2020s and 2030s, it can't stay astride the public policy. I mean, crypto assets are being used for ransomware, for dark web applications, and so how do we sort of frankly rein that in? This new form of potential private money. It does not have the three attributes of money, but for the use of ransomware, then it becomes a medium of exchange. I think there's actually a fair amount of clarity. And why did I quote Jay Clayton to say it crosses chairs, it crosses party lines, it crosses different philosophies? I mean, Jay and I really met as he was in this job, and he was in his job, and I was at MIT. I think there's a lot of clarity. This Howey test and these other tests, Reeves test. There's something called Gary Plastic, not Gary Gensler. But there's a number of tests that really is with all respect, we've been awfully clear on a bunch of this stuff. So I'm pushing back a little bit with all respect, and is that I think that Jay Clayton was pretty clear 4 years ago, or no, 3.5 years ago. I think 75 cases in this area, and you can go to the SEC website and see them.
I think yesterday we heard Chair Gensler comment that they brought 75 cases, enforcement actions against various digital assets. If you break that down, 37 of those didn't involve the sale of any digital asset at all. 37 were what we'd call ICOs, initial coin offerings. And oftentimes these were actual frauds. Only one of the 75 involves a digital asset outside of an ICO. And for obvious reasons, I'm not going to talk too much more about that case, other than saying it's definitely an outlier.
I've been clear. I think the Dow report in 2017, the Munchie order late in 2017, on and on. But I think we've got a lot of clarity, and it's not just these 75 cases we've brought. It's the law. It's the law if you follow what the law is.
Great.
In my judgment, when you're dealing with an alcoholic who doesn't want to admit they have an alcohol problem, to say that we have certainty, we have clarity is like the alcoholic saying, I don't have a problem. Like, this is the elephant in the room. If we don't address this, we're going to fall further behind.